Hello, everyone. This is Betty Meredith, President of the International Retirement Resource Center, and I'm happy to be your session host today for the Platinum Retirement Challenge Gray Divorce with Lily Vasiliff, CFP, MAFF, CDFA, President of Divorce and Money Matters and Wealth Protection Management. Among U.S. adults over age 50, the divorce rate has doubled since 1994. Contrary to expectations, long-term marriages are not immune, and the largest increase, 55%, is in first-time marriages of longer than 20 years. Advisors need to understand what boomers want and experience with gray divorce and the effect that gray divorce can have on retirement and financial security. As President of Wealth Protection Management, Lily Vasiliff is the nationally recognized expert in financial planning for wealth protection as a practitioner, leader, author, writer, and speaker. She is sought after for her seasoned experience and deep knowledge about complicated financial issues in wealth management and is called into cases which have national recognition. She is one of the distinguished trailblazers in divorce financial planning who has been a catalyst in developing a professional niche that has led to international movement and thousands of practitioners today. She's a highly regarded educator, trainer, and speaker. She is the author of Money and Divorce, The Essential Roadmap to Mastering Financial Decisions, that was published by the American Bar Association in January of this year. She's co-author of the Ultimate Divorce Organizer. She's co-author of The Complex Compensation Issues in Divorce, and she is frequently featured in national media such as the New York Times, the Wall Street Journal, Journal of Financial Planning, and other publications and print and radio media. She also testifies as an expert in the courts, and she has serves now as President Emeritus of the Board of Directors of the National Association of Divorce Financial Planners, and holds active memberships in many, many other institutions. And be honest with you, girl, I don't know how you do it. Where are you finding time for all this? And writing books as well. So, Lily, thank you so much for being here today. We're really looking forward to your presentation, and I'll now turn it over to you.
Well, thank you, Betty. I don't sleep. That's the key. So I am delighted to present today on a very important topic that I think all advisors should be aware of and also have some tools by which they can really genuinely help clients at this stage in their life. So this course is for advisors to learn about the triggers for gray divorce and how to recognize challenges that boomers face at their stage of life and how divorce further complicates financial security, especially for women. And we will identify 8 key areas for discussion with your clients who are going through divorce that you and they must not overlook. You'll learn about the divorce process on a fairly general scale, about the financial issues in divorce, and decision-making within the context of the law for very key financial issues. Lastly, I hope you will learn how to illuminate opportunities for clients to help them maximize their cash flow, dividing their property, and preserving wealth for the later years in ways that are unique to the divorce process and that are exceptions under many IRS rules. So let me give you a little bit of background on gray divorce and retirement. It's a genuine, real statistic. Every 10 seconds, a boomer turns 60 years old. And among the U.S. adults who are age 50 plus, the divorce rate, as Betty alluded to earlier, has doubled since 1994. Interestingly, the increase and the fastest growing population is in first-time marriages, and more than 55% of gray divorces occur with couples who have been married for a long time, for more than 20 years. Divorce risk is not spread evenly among the demographics of the boomers, and most divorced boomers are not living alone. So, what's it all about? What do boomers want? What will boomers experience? Why is gray divorce different than divorce generally? And why are gray divorced women affected so much more significantly than men? So, The easy answer is that boomers want what most couples want when they go through divorce. There are no special characteristics or particular reasons other than one time I heard my 98-year-old divorcing client tell me she was tired of taking care of her spouse. But beyond that, what boomers seem to want are genuinely what everyone wants: higher standards in relationships, to seize more opportunities to become fulfilled, and to feel entitled that they have a life that they can live more fully apart from their current partner. What will boomers experience? Well, we all know that statistics show we will have longer lives. We do have declining disability rates and somewhat improved healthcare systems. We have longer work trajectories and broader career paths, including those for women who have gained greater financial independence in recent years. But there's also the divorce echo effect that boomers experience. And this is when older individuals are more likely to be in remarriages. And as you may know, remarriages have an even more dire statistic of divorce. Second remarriages have a divorce rate of around 67%. And third remarriages, God bless those brave souls, have a divorce rate of 73%. Why is gray divorce different? Well, in general, the older you are, the more complicated your life is, financially speaking. At this stage in your life, boomers have a lot of challenges. They have demanding jobs that require 60 to 80 hours of time per week. They may have college tuition bills that collectively cost even maybe more than your client's house. They have perhaps financial responsibility of caregiving for elderly parents. And we've heard the stories about adult children who boomerang back home, unable to find a decent job on their own, and adult children who spend down your client's assets without financially contributing to the household. Adult children may be in conflict with your client in a family-owned business and put at peril family succession planning for that business. And what about children who come into a second marriage or a blended family? How do they integrate? And lastly, skyrocketing health insurance premiums and medical issues require more than your clients just to take it easy. How are boomers preparing for retirements? Well, this is our key question. With the transfer of wealth coming in this next generation, are boomers preparing for retirement? Great question. Statistics show that 29% of households age 55 and older have neither a retirement savings account or a pension. 36% of married couples who say that the partner is actually saving for retirement, 1 in 5 have no idea how much they're saving. And 21% don't even have a general sense of the value of their partner's retirement account. Are they, in fact, preparing for retirement is the question. 30% of respondents with at least one partner saving for retirement don't talk to the other about how much money they will need to retire. And nearly 40% of all couples surveyed disagree on the lifestyle they expect to live during retirement. And this is according to a 2013 Fidelity study. And not only that, half of them disagree on the retirement age. So despite these concerns, it's interesting that only 2 in 10 couples actually sit down to prepare a detailed retirement income plan to make sure or to ensure that they don't outlive their savings. Well, you see the ticking time bomb. We have, in general, mismatched expectations for retirement years. Everything from the amount that you're saving to what it will cost, to when you retire, to what you will do during retirement. We have a lack of knowledge about retirement savings and the resources available to your clients. There is clearly a lack of communication in most marriages about planning for retirement. And this is a kicker. There may be a potential age disparity between the two spouses of significance, and I call a decade or more significant. When you add divorce to this mix, you find that older divorcing adults will now be facing financial challenges on the same issues they have avoided talking about. They're going to have to look at their own assets and decide how to cherry pick or share equitably or equally the various kinds of assets they've accumulated. They may have to break up or reconfigure family-owned businesses. They may have to downsize lifestyles. And most importantly, they will negotiate retirement benefits between themselves. Many times, older divorcing adults who have substantial assets and have peak earning years will also deal with complicated compensation structures, such as restricted stock, stock options, executive comp packages, performance bonuses, capital accounts invested in partnerships, and employee-provided perks, everything from meal allowances to travel, financial, legal services, apartments, travel, and bodyguards. They will also have to determine future cash flows for support purposes in contemplation of when the earning years will cease. And outside of the normal scope of discussing routine daily living expenses, they may have to determine how an inheritance impacts their divorce, meaning does it affect the division of marital assets and liabilities or even support. We mentioned that gray divorce is not spread evenly among the demographics, and it is especially likely to occur among couples who are socially and economically disadvantaged, raising concerns about long-term health care issues and their wealth and well-being. It's also among couples who only have 20% of the wealth of most other married couples, and on average have half the wealth of someone their age who has been widowed. Older divorcing adults are really unlikely to recoup financial losses associated with divorce or to improve earnings powers to build up their savings. The time horizon is simply too short. And who is affected greatly? Older women who are vulnerable in a number of different ways from this generation. For older women, the loss of accumulated wealth and income is harshest if they've been out of the workforce for a significant period of time. Gray divorced women have relatively low Social Security benefits on their own record and end up with relatively high poverty rates. Approximately 20% of older single women rely exclusively on public benefits and live in poverty. The platinum challenge in retirement for gray divorce means that you may have a reduced economic cushion, longer life expectancy with less assets and wealth, increasingly complex family structures and dependence. And by this I mean we are seeing that the normal family with biological parents and children is only 1 in 5 families in the US today, which means we have families that are blended with adopted children, surrogacy, half children, stepchildren, you name it. We also have elder care issues and health care issues, and of course, the biggest one is the income uncertainty during these retirement years. So, here's where you need to perk up your ears. What do advisors need to know and practice? Well, clearly you need to recognize that gray divorce is the perfect storm that impacts your clients. And I invite you and encourage you to seize the opportunity to address the essential concerns and all the potential contingencies with forward thinking on behalf of your clients, even when your clients are unwilling to prepare, listen, or act for themselves. You should recognize that clients will have very unique needs after divorce during the retirement years that must not be ignored or postponed. So the 8 key points to address with your clients who are contemplating divorce, going through divorce, or nearly are divorced after the age of 50 include: review and or discuss credit rating with your clients, their individual financial identity. Do they have one? Do they have health care and long-term care insurance coverage? Is it affordable? Is it accessible to them? What is their Social Security eligibility? What will be an appropriate claiming strategy, specifically if there is a large age disparity between the spouses and if they intend to remarry, there will be a suspension of benefits. Clearly, you want to look at pensions, the policy plan, any benefits with that pension, whether it includes health care or COLA adjustments for future years, their estate plans and inheritances, updating beneficiary designations, looking at the short and the long term for when those inheritance might kick into play. Future families, are your clients anticipating having second, third, fourth marriages? And how to protect and preserve their wealth without any earning capacity during retirement years, or if they do plan to remarry or cohabitate with someone. So let's take a broader view and put it within the context of the law, because making financial decisions and analysis are all taking place within the context of the law. And how does the law look at gray divorce? Well, divorce, as you should know, is governed by your state law. Each state legislates its own laws for divorce, separation, and annulment. And a divorce occurs as a formal court procedure. It is a legal order or a legal judgment. All states, all 50 states now offer some version of no-fault divorce. And no-fault divorce defines any divorce where one spouse does not have to prove that the other one did something wrong in order to file for divorce. There are 2 kinds of divorce: contested and uncontested. A contested divorce is one in which spouses cannot agree, either about getting divorced or about any terms of one or more issues in the divorce. And what's divorce all about? It's generally about 2 major categories: children and money. If a settlement cannot be reached in a contested divorce through negotiation, ultimately the client may have a trial and a judge will make a binding decision. And trust me, when you go to trial, anything is possible. Generally, the result is dissatisfying for both parties. And the rule of thumb is, if they're both unhappy, neither one is likely to appeal because there's no clear win-win. In an uncontested divorce, which is the second kind, spouses have negotiated all of the issues. They've agreed on everything. They've reached a final agreement, and they do not need the court to intervene and make a determination for custody, property division, or support. An uncontested divorce will move quickly through the legal system. It's less complicated, less costly, and more likely to be the product of divorces who have done, of spouses who have done their own divorce, whether through a mediator or attorneys. And just so you know, about 90% of all divorces get settled without ever going to trial. It may be on the courtroom steps, but that's what the statistic is. So I mentioned earlier, what are the issues in divorce? Well, the financial issues include property division, child support, spousal support, also called alimony, and college for many states. In property division, most states determine whether the property is marital or separate. I'm going to point out in big cap letters, definitions differ greatly from state to state as to what is considered marital property or separate property. And all states will distribute property in one of two approaches, equitable distribution or equal/community property. There are only 9 states that follow the community property approach. Any property that is transferred between the spouses pursuant to a divorce order is a non-taxable event. The cost basis of every asset is transferred to the new holder of that asset. And even though there is no taxable event at the time of property transfer between spouses, absolutely you should pay attention to the cost basis and the tax impact of those assets if your client liquidates, sells, or holds the asset post-divorce. The tax impact should never be overlooked. The rules will vary widely again among every state, but usually each state picks an operative date to value the property, and that operative date could be anything from the date of filing for the divorce to the date of the actual divorce. Most property decisions, and this is important for you to understand, most property decisions are a one-shot deal. They cannot be renegotiated or reopened after the divorce is final. There are very few legal exceptions that exist for reopening a judgment or appealing a decision. The legal hurdles are extremely high, and this includes anything that clients believe was true and later found out on their own to be fraudulent. Even then, it may or may not come to that basis. And there was a gigantic case involving Madoff assets. So, as an advisor, what do you tell your clients? Well, the first is that they must persist in full discovery and accurate valuation. They must obtain all policy plan documents, as tedious as this sounds, to understand what the retirement benefits are, where the trigger dates are for initiating those benefits, and if there are survivor entitlements. I encourage every one of my clients and legal professionals not to overlook any difficult to value assets or intangible assets, such as unvested awards, private equity investments, family businesses, and even goodwill, celebrity goodwill. And don't forget that debts are part of property division too. So moving from property, let's look at financial support and lifestyle. So the definition of spousal support, or alimony as we know it, is a legal obligation of a person to provide financial support to his or her spouse during the marriage while the divorce is pending, or after marital separation or divorce. It is an entitlement system, and it's based on numerous statutory factors and case law in each state. And these factors and case law vary from state to state. It is not a guarantee. And only 10 to 20% of all divorces involve some element for a period of time of alimony or spousal support. And the courts are awarding less spousal support for shorter periods of time. That is a nationwide trend. And with the recent change in the tax law, the alimony deduction is the only deduction that was made permanent, which then impacts almost every calculation in divorce, since alimony is the only one where you can shift tax subsidy between spouses to achieve maximum cash flow. I wanted to dispel some divorce myths and really highlight you the facts. Spousal support awards are complicated to negotiate and far and few between to obtain. We talked about earned income during retirement years, and this is important for you to understand. There are no guarantees that both spouses will have sufficient means or capacity to support the same lifestyle they had during their marriage after divorce. There is no universal formula or standard for awarding spousal support, and only a few states have formulas for calculating support. Spousal support can be waived forever or preserved with just $1 a year award written into the divorce judgment. And courts, meaning judges as well, have very broad discretion over awards, and they can vary enormously among different county jurisdictions and even to the judge you have presiding that day. Spousal support, as I mentioned, is usually the very last piece of the financial puzzle to fall into place in divorce. And according to a survey by the American Academy of Matrimonial Lawyers, the top 3 areas of dispute and gray divorce are spousal support, by far and away, 83%. Retirement accounts and pensions, again, focused on annuity of income or annuitized cash flow, and business interests. The most common area of dispute were also houses and other real estate. What are the obvious risks? Well, you have ex-spouses entitled to a long duration for spousal support that are effectively being robbed because of their proximity to the normal retirement age. Many spouses are going to have to work past normal retirement age if spousal support terminates or is modifiable. In a gray divorce, particularly where neither spouse is working and they have to both survive on fixed incomes, being able to boost income with the spousal benefit can make a very big difference. Gray divorce is really about making a lifestyle choice, and divorcing on the cusp of retirement typically takes place in peak earning years for individuals that have a lifestyle reflecting the accumulation of their hard work and wealth. It is a time for powerful reckoning by the clients to realize that these peak earnings that have funded a household's mature lifestyle may or may not last much longer than a few years because of normal retirement age, and that this earning capacity may not be sufficient, or the assets that have been accumulated and now are being divided may not be sufficient to support two households post-divorce. Are people then inclined more or less to work past normal retirement age? Well, in survey after survey, significant percentages of workers say that they plan to work well past traditional retirement age of 65. And in a Gallup poll published in May 2017, 31% of non-retired adults said, sure, we're going to work past age 68 or older. And in another study published by the Employee Benefit Research Institute in March, 38% of the workers said they expect to retire at age 70 and beyond. According to the Bureau of Labor Statistics, about a third of Americans 65 to 69 were employed, even past age 70. A growing number of seniors are declining to or are unable to retire. And this trend is up 22% since 1994, fairly comparable to the divorce trend. So when the Federal Reserve asked retirees to identify sources of funds in later life, only 7% of respondents said that they had earned income from a job. If an individual works past normal retirement age, you should know that they may or may not be ordered by the court or the legal system to continue to pay spousal support to their ex. Some states have actually legislated successfully, or many more are seeking laws to terminate spousal support at normal retirement age, even if that spouse continues, or ex-spouse continues, to earn income. So think about the impact of this. Why is there a disparity between workers' plans and retirees' experiences? I'm just going to check back. Excuse me, I skipped a slide. Let's go first to what are the downside risks to working past the retirement age if you are divorced. Well, for the payor of alimony, you may be obligated to continue payments until you're no longer earning. That's a risk you take. And it may be difficult to seek modification downward of the amount that you pay if your ex-spouse's expenses have decreased and you're proving that they're less, because courts are generally protective of ex-spouses in old age. For the recipient of alimony, if you file for Social Security benefits while collecting alimony, your income may be high enough to have the Social Security benefits taxed at federal and state levels. And if you're receiving Social Security benefits on your ex-spouse's record, remarriage will suspend all benefits for 1 year until you requalify under your new spouse's Social Security benefits record. There is an elimination there of that stream of income for at least a year. And if there is a time gap, which I often see in my clients, between qualifying for Medicare and coming off of COBRA coverage, my clients or your client may have to go to work just to secure medical insurance, and that then puts at risk a downward modification in alimony. So why is there a disparity between the workers' plans and retirement and retirees' experiences? Well, there's a trash can over there, because the easy answer is life is messy. Health problems, layoffs, the need to care for a loved one, age discrimination, a scarcity of job openings in your client's particular area, any of these circumstances can and do push people into retirement far earlier than planned. And divorce adds yet another layer of need for both emotional and financial recovery that really may keep you from being so productive in the workforce. And the facts all suggest that great divorce is imperiling to wealth. So during the divorce process, what can you do as an advisor? How can you uncover opportunities to maximize income, to preserve wealth for your great clients? Focus on these financial areas. I have found these 3 to be of the greatest impact of providing confidence and a sense of security for clients post-divorce. The first is cash flow. The second, looking at the retirement assets. The third is dividing the retirement assets. Let's look at the first as being cash flow. Cash flow from the retirement assets. How do you get cash? Well, in divorce, remember I mentioned it earlier in this presentation, there are unique opportunities to do things that are exceptions under IRS rules. And under the IRS rule 72TC, you can withdraw cash without penalty before age 59 and a half from a qualified retirement plan, not an IRA, through a qualified domestic relations order, a QDRO. The QDRO must specify the exact dollar amount in cash and where it will be distributed to. If you are dividing an annuity, you absolutely should predetermine if the annuity is divisible during the divorce with the same terms between the ex-spouses for each spouse post-divorce? Or does it have to be transferred in ownership, or does it have to be canceled out and replaced with a new policy? Can it continue to be held jointly if the parties are divorced? What is at risk? What's the cost of ownership transfer, a division of benefits, or opening comparable policies individually? If the annuity is in payout status, now we have a different ballgame. Can those distributions be segregated in each spouse's name? And annuities will tell you time and time again different stories depending on who you contact, and each annuity company has very different rules. Thirdly, you should always identify if any loans exist against the retirement accounts by an ex-spouse, and you always should be dividing the account net of loans. And this is also true for whole life insurance that has cash value in it. The fourth point is that advisors, we know this, you always want to ensure direct transfer of retirement accounts from custodian to custodian pursuant to a divorce decree to avoid any possible taxes or penalties. This is true in divorce as well. And IRAs do not require a qualified domestic relations order. They do not require a certified legal order to divide them. They must be divided post-divorce. And an atypical situation I thought I would throw in here is if your spouse, if your client's spouse has received an inherited IRA and it is in payout status, they got it from their deceased parent, the ex-spouse to whom receives half of that inherited IRA must step into the shoes of their ex-spouse and continue to receive the same RMDs. They cannot recalculate that IRA over their own lifetime expectancy as they would be able to do with a straightforward IRA not in payout status. And the most important area that I really focus closely on for divorcing clients are pensions. Find out if the pensioner has multiple options for joint with survivor benefits. Sometimes it's 50% and sometimes the scale goes all the way to 100% of a lifetime benefit if the pensioner dies during the payout period. Does the alternate payee also have an election option at the trigger date? So in other words, once the pension has been divided through a quadro, does the alternate payee have their own election option to take it as a lump sum or as a payment stream? You should absolutely confirm that an ex-spouse has never signed a spousal waiver to the retirement account or plan benefits, either during the marriage at some point in time or during the divorce process without knowing about it. This absolutely affects the division of the pension in divorce and the survivor benefit calculation. And lastly, if the employee spouse dies before retirement, ERISA requires a pre-retirement survivor annuity be available if the pension plan offered the option to retire early with a reduced lifetime benefit. Very few divorcing spouses are aware of this. Retirement cash flows. Is there an opportunity to equalize income during the retirement years from all sources of income, meaning looking at Social Security benefits, RMDs, pensions, investment income, annuity income? And if you have a client who is a teacher or is in the military, very special conditions exist that may offer Social Security benefits that may offset Social Security benefits and affect how much the pension should be shared with that spouse if you are aiming to equalize retirement cash flows. The last section of this is really looking at dividing property and being sure you don't overlook some very important assets or debts that could affect your client post-divorce. And what's really often overlooked that impacts spending or savings? Reward points. mileage points, cash rewards, cash rebates, timeshare points, health saving accounts, tax refunds, tax loss carry forwards, depreciation recapture and tax liability on selling a vacation home if one spouse is allocated that as an asset, and even auto leases. In some states, case law suggests that it's possible to force a decanting of a trust to either divide the assets held in that trust or to access income from that trust. And in divorce, life insurance is typically required to securitize any support obligations. One of the really key parts of divorce for individuals who have family-owned businesses is how do you value them and what stream of income will continue to be provided or divided between the two spouses. And family businesses have different methods of how you determine your spouse's share, such as ownership interest, the value of a capital account, the buyout or buy-sell agreements between partners, any appraisals that have been done, informally or formally, a business valuation, and usually have competing business valuation experts, or key man life insurance. One of the most controversial areas for valuing a family business is the concept of double dipping, and this refers to the double counting of the family business as both an asset in property division as well as an income stream in the award of support. The theory is premised upon the fact that the same cash flows that are capitalized to determine the value of a spouse's business are also the same component that are used for spouse's income from that business. The result of a business valuation is very often misinterpreted and misapplied by the courts, and we always see a battle of the experts. But in the most simplest of terms, it really comes down to deciding if a business valuation is based upon the averaging of past income, or is it a projection as to what future income will be. The methodology for a business valuation, as well as the premise of double dipping, are critical determinants in a gray divorce. The platinum challenge of retirement is made so much more complicated by gray divorce. And just as in every divorce, there are sequential financial phases to complete, and these indicate that the financial planning process is really not linear, and clients plus professionals are often sidetracked by emotions, legal and psychological issues. And it's based on a legal process. It is truly more focused on the past than the future. So what do? You call in a Ghostbuster, you call in the divorce financial expert, and the role is defined and circumscribed very cleanly by what the legal process is all about. The hats we wear could be as an advocate, as a neutral, or as an expert witness. And above all, apart from all other advisors involved in our clients' lives, we actually have to play by the rules of somebody else. We are in someone else's sandbox, that of the legal professional. So we are fee-only financial planners that have absolutely no bias of selling product in this process per se. We are trained in interdisciplinary legal and financial issues, and we adhere to our own professional standards, codes of ethics, and protocols. As any divorce professional, we must carry professional liability insurance, and believe me, as a financial expert in this process, we are often the lightning rod for very unhappy and dissatisfied clients. Divorce is especially complicated and expensive for people over 50. As an advisor, you can demonstrate how much you care about your client's well-being by pointing them to a divorce financial expert who will save them time and legal fees and money during this process. Your client will benefit from the important step of understanding their financial situation within the legal context. They will prepare with a financial expert who will work, I hope, seamlessly with their legal professionals, and they will initiate a divorce with a greater sense of confidence because they will know how to have prepared for it. In summary, the trend in gray divorce reflects a shifting meaning of marriage in the United States. Divorce has become acceptable if a marriage is unsatisfying. More boomer women initiate divorce by 66% and claim satisfaction, almost 70%, than men. And for some older adults, divorce is actually a liberating event from a relationship that simply has run out of steam. But no matter what the trigger or the reason for gray divorce, coupled with the general reluctance to talk about retirement planning throughout a long-term marriage, this really comes down to a combination of dangerous silence and ignorance of your parties. And so as an advisor, you should be in a position to provide clarity on the topic, claim some kind of authority to help guide them, and offer a better education for more effective approaches for gray divorce. Because wisdom will cut two ways, keeping your clients from developing false ideas and expectations during divorce, and keeping your clients from making ignorant decisions during divorce. The key takeaways I hope you have from today's presentation is one, most importantly, ask your client about what they project as their lifestyle and what their needs will be post-divorce. Focus on projected cash flow needs and how to replace income. Manage their expectations and help them by referring them to a divorce financial expert, and really admit that you know what you don't know. Educate them about the interplay between short or longer term alimony and Social Security claiming strategies, and revisit all their estate plans, update the beneficiary designations. But most of all, be a true neutral if you are working with a divorcing couple, if you hope to retain both or either one. So I appreciate your attention today, and I will hand it over to Betty for some questions.
Well, thank you, ma'am. Oh my gosh, that just, I just didn't realize how complicated this is, Lily. And I know CDFA, and then what's the other? There's another divorce certification, correct?
So the primary divorce certification is the CDFA, which is a for-profit organization that grants the training and the certification. Then there's the not-for-profit professional association, whereby practitioners then join subsequent to being training and certified, which is the National Association of Divorce Financial Planners.
Okay. So, and this has been, this is a relatively new certification, 20 years? Maybe.
So it's gone through, everybody goes through its own growing pains. So the certification started in various different groups and organizations, probably I would say maybe middle to late 90s.
Okay. So it is still relatively new compared to CFP and others.
Absolutely.
Specific. Interesting.
Absolutely.
So if anyone else has questions right now, I have a few of my own, but if you have questions right now, please feel free to enter them into the chat box, and we'll take a look at them as they come in. I wanted to ask, what's the difference between, let's say, are you seeing more gray divorces closer to age 50 or 62? How much is it before retirement versus after people are retired?
So generally speaking, it's before retirement, and it's really in that decade at, let's say, 60, you, in normal situations, if you were 40, you'd have, half the years, so say 15. But now you're at 60, and there's only a 5-year window until normal retirement age. So the long-term marriage entitlement falls away. And that's what I meant by being robbed, because in many situations, this is exactly what happens. You've been dependent on income for a long period of time, and all of a sudden it disappears, that opportunity to rely on it.
Another question here, can you address the ramifications of the tax law change?
It's a big one. There's many, many, many subtle nuances to this. So the very first one at the outset is alimony was and is, until the end of this year, until 12/31/2018, a dollar-for-dollar deduction against taxable income for the payor and taxable income to the recipient. It allowed the payor and the recipient, if they were in different tax brackets, to actually have Uncle Sam subsidize the difference in their tax rates, to allow the payor to pay more because he got a tax break, she got a tax break for it. That tax subsidy is completely gone. And this is the first time it's happened in 74 years. And it's the only deduction in this tax law that has been made permanent. And what effectively it means is that you are paying support from your net income now. And we all know that net income is much less than gross income. And it's a wait and see attitude if it's going to be repealed, modified, changed, who knows. But it will impact many, many, many individuals going through divorce. And in fact, we're seeing a rush of parties to divorce this year.
So, I mean, is it on anybody's radar in Washington? Are you plugged into some of the...
It's on everyone's radar. Absolutely everyone. Even the Academy of Matrimonial Lawyers is addressing it. We're all doing our little mathematical calculations everywhere, and I'm doing a number of different speaking engagements on what it means for strategy in divorce. So, I mean, if you think about it, many times people will pay alimony in the form of subsidizing a mortgage payment or property taxes, or if they keep a vacation home as part of their settlement. Well, if there's a cap on mortgage interest, or if there's a cap on property taxes, or whatever, you're really much more limiting in what your ability to pay for and get a tax deduction for will be. And there are many times where parties will buy out the spouse with the equity of the house by taking on a HELOC. Now HELOCs are no longer tax deductible. So there's a lot that this affects.
Oh my gosh, girl. So glad there's people like you that take care of this and
thank you,
make us aware of these issues. Oh.
Yes.
All right. I think that's all the questions we have at this point. And Lily, I think, you're available if anybody else has any questions afterwards that we can forward that to you. I want to thank you so much for being here today. And it's just really, it's sad to see that these divorces are happening for people that have been married a long time, and that's just a tough time of life to have things happen.
Well, keep in mind, some people are really happy to be divorced.
Right. True. Yeah. That they've been, keeping the good face for a while, and now they're ready to do something else. So I get that. All right. Thank you again, everyone, for being here with us today. And thank you, Lily. And I just want to remind everybody to complete your evaluation after the webinar is over. And Lily, if you can just forward on to that next slide there so we can cover what we've got coming up the next month here in terms of presentations. So it looks like we've got Wade Fowl Month. I didn't realize this when we put this together. But he has he wrote a book last year on retirement income with home equity, and he also has a new book out now on how much I can spend in retirement, and it's really got some great research in detail behind, the math behind how we need to think about how we take money, how we can help coach our clients and guide them towards the money that they take out of retirement accounts. So that'll be a live presentation on May 17th and a rebroadcast on May 1st. And that's all today, everybody, for this monthly Retirement Professional Development webinar series. Lily, myself, and our team here at the Retirement Resource Center, thank you for participating today, and have a wonderful rest of the day, and we look forward to being with you again in the near future. Take care.